We looked at the application process for an FSP license in Chapter 5. The registrar will include certain conditions on every FSP license, and it is part of the management function of a key individual to ensure that these conditions are met. Chapter 10 looks at these conditions and unpacks the requirements that are contained in typical conditions. You will also gain an understanding of the effect and meaning of suspensions, withdrawals and reinstatements of the authorization to carry on business as an FSP. We will look at the various offences as defined in the FASE Act, as well as the civil remedies and anti-money laundering controls. A FSP phase license carries conditions. There are standard conditions and there are conditions specifically applicable to the FSP license. Specific conditions include reference to the categories for which the FSP is authorized, as well as any other applicable conditions about the fit and proper status of the key individuals who need to obtain certain qualifications within a certain period of time from the date of licensing the FSP. The licensing conditions may also include exemptions applicable to the FSP. FSPs must adhere to the conditions and must also ensure that there are adequate systems and processes in the business to ensure compliance with the conditions. Where representatives and key individuals work across various sub-products and license categories, there must be internal controls to ensure that the financial service they provide corresponds with the specific license conditions and restrictions. An FSP may request additional product categories to be added to its license, and it may also have more than one license because of the structure of the business may be such that products are grouped together, which makes it logical to have a specific license for that part of the business. The FASE Act requires that a certified copy of the FSP license must be displayed in a prominent and durable manner within every business premises of the FSP. There are a few standard conditions that appear in each license. For example, details about the financial services that may be offered, details about informing the registrar in writing within 15 days after any changes, details relating to key individuals and appointment of new key individuals, details about the representatives register and any changes thereto, a condition that the FSP may not in any manner change the name of the business as reflected in the license concerned, and that the financial service provider must at all times ensure that any financial product in respect of which the provider intends to render financial service qualifies as a financial product contemplated in the Act. If there are certain changes, the FSP must have procedures in place to ensure that the registrar can be advised of the change within 15 days after the change. There are designated forms to be used for this purpose. The changes may include any of the following. Condition 2 relates to reporting changes relating to key individuals. This condition requires that there must be a key individual appointed in terms of a license at all times, and that the key individual's details and changes in personal circumstances of key individuals that affect his honesty and integrity are maintained and updated. The FSP must inform the registrar if and when there are changes to the approved key individual's positions. This means that when a key individual leaves the employment of the FSP, the necessary profile change must be done within 15 days. In addition, Section 8 of the Act requires that when a key individual leaves the employ or is replaced, or there are changes in the person's personal circumstances of the key individual which makes him no longer fit and proper, the key individual must not be allowed to take part in the conduct or management or oversight of the licensee's business in relation to the rendering of financial services. A newly authorized FSP must submit the representative register within 15 days of authorization. Thereafter, updates to the register must be sent to the registrar every 15 days. If there is a change in the name of the business, the FSP must ensure that the name change is not in conflict with any other law and complies with other applicable laws such as the Companies Act or the Banks Act. And the FSP must disclose compliance with other applicable laws to the registrar. If the registrar is satisfied that the change of name is lawful and has approved the change of name, the FSP will be issued with an amended license. Only when the amended license is issued may the FSP continue or start with providing financial service under that name. The FSP must have internal controls and procedures in place to ensure that any financial product regarding which the FSP wants to render a financial service qualifies as a financial product as required by the Act and is lawfully issued by the relevant product supplier. Only financial products or product suppliers whose products are authorized by an authority or by approval or rights granted under an appropriate law may be sold by FSPs. The registrar may suspend or withdraw a phase license subject to certain conditions. The license may also be reinstated, subject to certain conditions. The diagram below indicates the steps before the registrar may suspend or withdraw a phase license. The registrar may suspend or withdraw any license if the registrar is satisfied on the basis of available facts and information that the licensee no longer meets the requirements in terms of fit and proper, that the licensee didn't disclose all required information upon applying for a license, or submitted false or misleading information, that the licensee failed to comply with any provisions of the Phase Act, or the licensee still owes levies, penalties, or administrative sanctions to the FSB and hasn't paid it. Notwithstanding the fact that the registrar must follow certain procedures before suspension or withdrawal, the registrar may do certain things on an urgent basis if there are reasonable grounds that the public or clients may be substantially prejudiced. If such grounds exist, the registrar may provisionally suspend or withdraw a license. The registrar must inform the licensee of the grounds and the period, as well as allow the licensee a reasonable opportunity to respond thereto, and to provide reasons why the provisional suspension or withdrawal should be lifted, or why the period and terms should be changed. The registrar may publish the provisional suspension or withdrawal in the Gazette, and if necessary, by means of any other appropriate public media. The registrar must consider a response received from the licensee and may decide to lift the provisional suspension or withdrawal, or make it final. The licensee must be advised accordingly, and notification must happen in the Gazette and other media if necessary. If a license is suspended or withdrawn, the licensee is not authorized to act as an FSP. If a license has been withdrawn in terms of Section 9 of the Act, which deals with suspension and withdrawal of licenses, the person is debarred for a period specified by the registrar from applying for a new license, and the registrar may change the period if there are good grounds for the change. Before suspending or withdrawing a license, the registrar may consult any regulatory authority. The phase registrar may and should consult another regulator if the FSP concerned is also authorized or licensed for business under that regulator. Section 8(7) of the Phase Act has certain implications in respect of the certain requirements for FSPs that are also accredited under the Medical Schemes Act. If an accredited medical schemes FSP loses its accreditation in terms of the Medical Schemes Act, the phase license will also be deemed to be suspended or withdrawn. Similarly, if the accredited phase FSP license is suspended or withdrawn in terms of the Phase Act, it will also lose its accreditation in terms of the Medical Schemes Act. The Act lists certain offences which, if convicted by a court of law, may result in a fine of a maximum of $1 million or a prison sentence of a maximum of 10 years or both. The offences which carry these penalties are the following: contravention of or failure to comply with, failure to get a license to operate as an FSP, failure to display a phase license, conducting financial services with a person who is not licensed for such services, failure to ensure that those role players that need to meet the fit and proper requirements of honesty and integrity, failure to ensure that representatives are fit and proper, failure to ensure that representatives act only on behalf of authorized FSPs, failure to submit compliance reports, failure to debar a representative, failure to maintain and keep records as required, failure to have financial statements audited and reported within 4 months, carrying on business with an FSP after the registrar declared the business as an undesirable practice, failure to rectify the effects of an undesirable practice within 60 days, deliberately making a misleading, false, or deceptive statement, or concealing any material fact, giving an appointed auditor or compliance officer information which is false, misleading, or conceals any material fact, pretending to be an appointed or mandated representative, civil remedies open to the registrar. The registrar may approach any court with jurisdiction for a restraining order against a person if the registrar has reason to believe a person has or is going to contravene or not comply with any provision of the FASE Act. The court may also order that person takes appropriate remedial steps to rectify the consequences of the actions or omissions, including any prejudice or potential prejudice to clients. The registrar may also approach a court and take legal action against a person who has contravened or did not comply with the provisions of the FASE Act for payment of money as compensation to anyone who suffered losses as a result of the non-adherence or non-compliance with the Act, payment of a penalty for punitive purposes as determined by the court, the payment of interest payment, the payment of legal fees incurred by the registrar as decided by the court, and the payment of the balance of funds that must be distributed to those who suffered losses. There is an obligation on FSPs who are accountable institutions as defined in the Financial Intelligence Center Act to have all the necessary policies, procedures and systems in place to ensure full compliance with FICA and other applicable anti-money laundering or terrorist financing legislation. The FASE Act does not have specific penalties for non-compliance with FICA requirements, but the FICA imposes severe penalties for non-compliance. Therefore, FICA penalties will apply if an FSP does not comply with the FASE requirements in respect of FICA. We discuss FICA in more detail later. Where a person does not submit a return, information or document to the registrar as required by the FASE Act, that person is liable, in addition to other legal action instituted by the registrar, to pay a fine of up to R1,000 as determined by the registrar per day for every day that the return, information or document is late, plus interest. If a person does something in relation to the Ombud for financial service providers or in relation to an investigation by the Ombud that could be regarded as contempt of court by a court, the person is guilty of an offence and liable on conviction to a penalty which could have been imposed by a court. A person who anticipates a determination of the Ombud and does something to influence the determination, or who willfully interrupts any proceedings of the Ombud, is guilty of an offence and liable on conviction to a fine or to imprisonment for a period not exceeding 1 year. We saw that in terms of Section 7.3 of the FASE Act, FSPs are only allowed to conduct FASE-related business with other authorized FSPs. Similarly, FSPs may only provide financial services in respect of products of product suppliers that have been authorized under applicable legislation. The key individual must ensure that the FSP has procedures to ensure that, if the provider does any financial service-related business with any other FSP, such other provider is properly authorized. We mentioned previously that contravention of or failure to comply with Section 7.3 of the FASE Act is an offence subject to penalties. This section requires that every authorized FSP or representative may only conduct financial services-related business with a person rendering financial services, if that person has, where lawfully required, been issued with a license for the rendering of such financial services, and the conditions and restrictions of that license authorizes the rendering of those financial services, or if that person is a representative as described in the Act. A summary of this chapter. FSPs must adhere to the conditions, and key individuals must ensure that there are adequate systems and processes in the business to ensure compliance with the license conditions. The licensing conditions create certain obligations for FSPs, and these conditions must be complied with on a continuous basis. The phased license may be withdrawn or suspended by the registrar under certain conditions. The Phase Act describes the various offences, and when offences are committed, a court may impose a fine of 1 million rand and/or imprisonment of 10 years. The registrar has certain civil remedies, which include getting restraining orders or payment orders. There are certain anti-money laundering controls built into the Phase Act, and FSPs must comply with as such. The Phased Act also allows the registrar or FSP to raise levies in respect of authorized FSPs. Authorized FSPs, regardless of product categories, pay annual levies to the Ombud for financial service providers. There is a responsibility on FSPs to only conduct phase-related business with other authorized FSPs.